I brought it back from Orlando.
Hey, everybody. Greg, Chuck, Jesse, and Aaron is actually, I know everybody tunes in to look at Aaron the whole time and drool, but he is in a naturalization interview today out in Colorado. We were all together, by the way, just last week. We were in Orlando at the annual conference of the American Immigration Lawyers Association. And it was a terrific conference. Jesse did a great job in his panel. He spoke on preparing for litigation. Two great co-panelists, by the way, Ron Klasko and Brian Green, both excellent lawyers in their own right. I have to tell you, Jesse, other than my own panel, I didn't sit through another panel the whole way. And I sat through you.
I did, and I saw your tremendously talented son also came up and congratulated me, and he had a great result in the case that we worked on. But yeah, no, we had some fun. It was great.
Phil is a great litigator. I wish he worked for me.
I wish Phil worked for me.
I better get to him. Hey, I want to touch first on the status of the 601A case because we're about to file today I think what we're filing it is notice of supplemental facts is what we're calling it. And the supplemental facts are the great casework that you all provided to us. We would have filed this earlier today before this, but we have to tweak the presentation of the information for the judge. Our motion's done. I mean, the legal work is done, but we have to redesign how the judge, who's 88 years old, can look at the facts. See, we have to not just say, hey, these cases are cases, but we have to prove that immigration took them out of order. So we had to go online, print screenshots of when stuff was filed, and we're lawyers. We're not just graphic designers. Well, maybe Jesse's a graphic designer in his free time. I don't think so. But that's going to be filed today, and we'll send you all a copy of that as well. It's just a quick thing. Hey, but there's a couple things that I wrote it. I drafted. Jesse drafted it first. I changed it. I think it's a good conglomeration. When you have 8 lawyers on something, I don't know if any of you have herded cats before, but basically it's like that. It's like herding cats, but it's a really good product. But the thing I think I slipped by my co-counsel was noting that now that the Immigration Service is at 50 months, they are 900% over the historical processing time. I just love throwing that out there. 900% over historical processing time. What can you say? So that's where that is. Nothing else has happened in the case. In our joint status report that we filed last week, I'm going to pull this up so we can kind of go over it. Folks are wondering, what is it, Jesse? What is a joint status report? What is a joint status report, Jesse, from,
Yeah, I think the courts like it when the parties get together and develop a plan. So the court, knows what's coming and knows what's going to be discussed. It also gives a chance for the parties to think about settling the case without bothering and using the resources of the court. So, we've traded barbs back and forth about how this case should go and not reached much consensus.
It wasn't much of a joint status report, was it?
No.
Now, the judge asked for this. He said, I need a joint status report. The first thing the judge asked for in that is, hey, there's other cases in my court.
Yeah.
Are they related? Are they part of it? And so we had to find those. He didn't tell us who they were, right? So the government had to tell us who they were, although we found an additional one besides that. And those cases were filed after ours, if I'm not mistaken, Jesse. They were both filed after ours. So they would be, if the judge granted class status, those folks would be eligible if they wanted to join the class. They didn't want to join the class. But that was section 1. Hey, there's these other cases. All right. Judge asked us, Jesse really drafted this part. Did we want to be consolidated or did we just not care?
No, I don't think we took a position on that. It's not, we were switched. The judge has already kind of moved us over to his docket, whether we're going to be consolidated or not,
It doesn't matter because the facts of those cases are identical to ours. They're not, there's nothing in them that changes how. So we took the position, we don't care. One of the other plaintiffs opposes consolidation in the case. In fact, both other cases oppose consolidation in the case. The defendants, the government, says they don't care. So we'll see what the judge does. And so basically, the two principal parties, us and the government, we don't care. You want to add them, you don't want to add them. It's not going to change us. Those folks didn't want to be part of the case. So there you go. The judge asked us if whether the plaintiffs in all these cases are members of the class, and my answer was almost. There was one case that was filed before a year, but that within a year, within 3 years they're current. So that was it. The judge also asked whether and it's kind of, if the judge consolidates, should the already filed, drafted, briefed motion to dismiss apply against those people? And that's obviously they don't want it to, right? Because they didn't have any part in drafting a response to a motion to dismiss. Although I'll tell you, our response to the motion to dismiss is just damn good. It is. Jesse, Greg, it's good. It's really good.
Yeah. By the way, because people were wondering, the only actions we have seen in the entire month of June are 2 denials of expedite requests on our plaintiff cases.
Well, what is the memo that one of our folks sent us, that they had used the congressional liaison or senatorial liaison, and the government responded to the liaison with, I think, something like, "Yeah, we don't do expedites."
Yeah.
Which is going to look good when they now come back. See, we didn't see if the government responds to our notice of supplemental facts. In case they're watching. So that's the case. That's where we are. We did ask, if I'm not mistaken, we did ask the court for a joint status for a conference. All right, plaintiffs request a Rule 16a conference, and we haven't. That was filed 11 days ago. We don't have anything. There's nothing you can do as lawyers to make a judge act on your case faster. You can't file a mandamus against the federal judge. Although, oddly enough, you can file a mandamus against the Board of Immigration Appeals because they're not judges. They're mere functionaries in the Department of Justice. All right. So that's kind of the 601. I didn't put a little banner up. I feel bad now that I didn't put the banner up. We put the banner up real quick, and then I can say, yeah, we put the banner up. So that's what we just talked about for the last 7 minutes. So if you're just seeing this, go back, and you'll see our discussions there. Hopefully I covered all the salient points. Aaron, who is our lead counsel in the 601 litigation, is not with us today, which is fine. It's okay that he's not. But what's going on in that case, this is the Ashtari case, is that the government response was due to the complaint on June 16th, last Friday. Okay, it was 16th, right? And the government called us and said, hey, what's your position? And if we want more time. And our response was, well, if you agree not to file a motion to dismiss, we'll give you 30 days. But they wouldn't agree to that. So we said, no, we don't agree. And so the government then filed on their own a motion for more time. We opposed. The judge basically immediately gave them more time, but only gave them 2 weeks. So the response to that 601 complaint, and I should go add that in there. The response to the 601 complaint is now due Friday. So that's good. We weren't there last week anyway. So we were all out of the office last week. So this is good news. And we will, by Friday, we'll get the response or a motion to dismiss. We'll let our plaintiffs know what's going on, and we'll move forward on that case. There's also been no movement, if I'm not mistaken, Greg, on those plaintiffs yet either.
I think one.
Oh, yes, one got approved.
Yeah. I think though the bigger point for the audience or anyone watching is this. I've seen this because I only, like I said, I'm a one-trick pony. The government has really just made a stand on the hill. They're going to die on this hill of whether it's the State Department or USCIS. They don't believe that there is any delay ever. There can never be a delay.
There's never a delay.
Never delay.
Why can there never be a delay, Josie?
6 years, 8 years.
Why? Why can't there ever be a delay? What?
They never have to make a decision. It's completely up to them. Yeah.
So they don't ever. You can pay them money.
Yep.
They can take as long as they want.
Yeah. I mean, let me just give you an example because this is, and I'm pissed today about this.
Right? I can tell you why.
I know I'm aggravated. So I represent a number of students in J1 applicants, and those are coming on exchange programs, and there's a time-sensitive window where they have to come in and go to school this fall, let's say. And they've held people in abeyance abroad for 8, 9, 10, 11 months, and they've deferred their admission date, and they can't do it anymore. And these are people who have fully funded rides to like great universities, and they're 20 years old, 24 years old, and the government comes back and and now they're saying there's no reason why we would ever have to issue these decisions, and they cite to judges who've been convinced that 3, 4, 6 years of delay is appropriate. Now, those cases are all immigrant cases, and I still think that's BS. But my goodness, I mean, talk about having no sense of what this actual visa is intended to do. It makes no sense, and it's a shame that we have executives like Blinken who go out there and trot out how they support these students, and then they have their minions go out and try to kill their ability to come to school.
In many ways, Jesse, this administration is worse than the Trump administration. At least they told you in the Trump administration, yeah, we're not going to do student visas. At least they told you.
Yeah.
These guys are saying, please come to America on a student or J1 exchange. Oh yeah, we're not going to work on your case.
Yeah.
This last week there was a Department of State. So at our annual conference, the Department of State deigned to show their face. They showed up, and there was an open forum. I mean, I don't know were those guys enclosed in cages so nobody could get to them? Oh no, wait, they were up on a podium. So they were up on this giant stage, probably so lawyers wouldn't just go after them like crazy. But they had excuse after excuse after excuse after excuse about why they aren't timely adjudicating cases.
COVID.
Yeah. COVID. We don't have anybody working for us. Trump closed the Foreign Officer Academy. Nobody wants to be a Foreign Service officer. Every excuse under the sun other than, hey, we're using technology to do your cases faster. Thank you very much. That's the one answer you didn't get, except in the context of, since Modi was in town last week, hey, we're going to let Indian nationals renew their H-1Bs in the United States. Like we did 25 years ago.
That's probably a good idea since it's going to be 60 years before any of them can get green cards. So, no, I mean, it's fine. I mean, I think a lot of them, listen, I love AILA. It's, I used to work for them and I love the community, but I really do have my own like kind of suspicions about what government officials tell me. And I used to be one too. Like, so I'm kind of like, I don't know if I don't belong in any bucket.
Are you saying you don't trust your former colleagues?
No. I just think that this administration has never really wrapped its arms around the magnitude of the problem.
Oh no, they clearly haven't. You're 100% right.
Yeah.
Or if they have, they just don't care, which is weird because the woman now in charge in the White House of Immigration is Betsy Lawrence. I don't know if you were there at AILA when she was at AILA.
She's the best. I like her.
She's amazing.
Amazing.
So what that suggests to me is that her efforts are being stymied by other people in the administration. There's no other explanation.
I don't want I mean, this is about as far into the political weeds as I'll get, but I don't know. And I don't watch much of the news, but when like Biden is like reading things like God Save the Queen and like,
that was actually quite funny, by the way.
And like, he's like end of quote. And I don't want to say like, I don't know if he's there.
I think Biden's fine. Anybody's had
do you?
Knows
about I also do.
Look, between Biden and Trump, it's not even a conversation, right? I mean,
no, Trump. Let's not. Yeah, but let's not go to like the Clippers and the Browns here.
Biden will be the nominee. Biden will be the president. And
he needs to get. Listen, he needs. It's like when you're trying to win a championship, right? And like you have people like Chris Paul going to and they're all just trying to shuffle it around. you need to have your immigration czar who is going to wrap their arms around, because we have in a country. Well, listen, why do we have inflation issues? Why do we have labor?
We don't have enough people.
We're getting older. Look at Europe. How can we address this? I mean, all of these things kind of, it's not just one thing. And I think this country, like we don't understand health, immigration, economics. It all ties together. And like, we just seem to divide and not conquer. It makes no sense to me.
Did you hear the choir singing in the background?
I'm seriously so aggravated. I'm so.
The choir is singing with you, Jesse. So there is.
Well, there was a development last week that at least our friend Cyrus Mehta seems to think might make a difference on some of this, which is the Supreme Court decision in U.S. versus Texas, which is a case that has really very little to do with the issues that we're litigating. But basically said it just makes it much more difficult for people to challenge government policies, particularly in the enforcement space. But Cyrus seems to think it gives the administration a lot more room to maneuver as far as rolling out policies where they, in the past seem to fear litigation, not just from us, but litigation from the litigation from states and litigation from anti-immigrant groups. So, if we're putting on the optimist hat, maybe
like the STEM litigation. I mean, the STEM litigation stopped. But it goes both ways. If the Republican comes in, it's going to be a bad case. I blogged on this issue as it relates to DACA. I think it's a great case to tell Judge Hannon, just let my people go. You don't have the.
Cyrus seems to think that it could have some impacts on some things like backlogs and visa bulletin and
visa counting. The biggest thing is visa counts and visa.
We'll see if they take a more aggressive posture as far as rolling out policies that in the past they might have said, I don't know, we're going to get challenged on this. Now they might be a little bit more willing to.
Craig, that's the difference between Republicans and Democrats. Democrats say, "Oh, we might get challenged." Republicans are like, "Screw you, we're doing it."
Right, but this time the Supreme Court seems to basically give them. I mean, it should move the needle a little bit.
Well, the other thing it should do is it should allow people to understand that, as Chuck was alluding to, that public charge rule, if it comes back next time, is going to be a lot harder to challenge from the other side, right?
Yeah.
You have.
This definitely cuts both ways if we ever get really anti-immigrant.
So I do think you're right, but it also kind of, and I'm always nervous about this, giving the power of the executive branch too much. That's why, in the same sense that, hey, listen, great. Give the executive branch the authority that it has. But at the same time, we have district court judges who are afraid to use their Article 3 powers to stop ridiculous delays and arbitrary decision-making and all of these things. And I need some people in Article 3 to understand that they can't give away, they're put on the bench for a reason.
Well, there's an Article 2 as well. And
is it?
Job needed one of those other two parts, but have to worry about it, right?
Oh my God.
So, all right. Next thing we want to talk about is the EB-5 case. The EB-5 case, which is today the IR case, is still pending. The government has, if my math was right, I believe the government has to, I'm just checking it right now, has until July, I think it was 14th or 15th. To get us a discovery in that case. So hopefully we'll get that relatively shortly. Here it is. I'm going to double check in the IR case when that's due for the EB-5 discovery. This determines the whole case. The discovery we're getting then allows me to write a motion for summary judgment because I can prove to the court that they're not following a visa availability approach. They're just not. First of all, that's completely irrelevant anyway, because you should be shooting first in, first out. But visa availability is, hey, if my visa is available, I should get it, which means there should be nobody but Indians, nobody but Chinese in the backlog. And we know that's not the case. Yes, the government has until, let's see, my motion for summary judgment is due 7/28. And let's see, open up the government has until July 14th. So we've got about 2.5 more weeks to get that information. So that's where we are on the EB-5 case. I'm doing a terrible job of changing the little headers here, aren't I? I got way too many headers. Way too many headers. So EB5, another 2.5 weeks, we'll have the information from the government. Now, Greg, Jesse, Aaron, if he's here, let's talk about our big announcement today. Greg?
Were we ready to announce that today?
Yes, we're going to announce it today because we're going to go live with this in the next couple of days, man. Come on. Chop, chop. We're ready to go. So we're not taking plaintiffs yet, but what is this, Greg? Why are we suing the government, the USCIS?
Well, so there were two groups. I guess I-130s and I-129.
Yes.
Are we talking about the other one too?
Yes.
Okay. So we've been kind of monitoring which categories have gotten. First of all, let's take a step back. USCIS, regularly says that they prioritize U.S. citizens, and we have two categories where processing times post-COVID have gotten considerably worse than they were before, to the point, and I think Jesse and Chuck, when we were talking about this in Florida, we're basically in agreement that that for people that actually are here in the U.S., whether they come in, basically saying they're coming in on a tourist visa, but are really, eventually going to file for an immigration benefit like adjustment of status, that they are in a much better situation than the people that are patiently waiting abroad. And that would include people who are immediate relative beneficiaries that are filing I-130s, and people that are filing the beneficiaries of I-129F fiancés of U.S. citizens. Those processing times have at least tripled over the last year and a half, I think, when we were going through looking at the trend report.
Oh, easy.
Without any explanation from USCIS about what's going on. And of course, it's not like everything else got faster. It's just that the agency seems to be, getting worse and worse in a lot of different categories. But in those two in particular, separating U.S. citizen spouse from their fiance.
Well, Greg, let's make a point, though. The Immigration Service has gotten faster for naturalization cases,
right,
and for immediate relatives whose spouse is in the United States.
Right, but I mean that's true. Although I would say on citizenship, that has been, they're getting to the point where it's sort of like the normal standard that they've always said for years and years is what's normal. So they're not doing it anything extraordinarily fast. They're just doing it at the pace that they're supposed to. That is a category that's working. Naturalizations, adjustment of status as well is, it's not like they're going like earth-shatteringly fast. They're just going at what would be considered an acceptable pace. That's if it takes slowing everything down just to get to normal paces on some of those categories, they have a problem. They should be at least at normal on all their categories, and they shouldn't be slowing anything down.
Well, I mean, I think the clear, having done this now for, the 3 years and change that we're doing these cases, it's quite clear what's happening. It's the little Dutch boy syndrome.
Yeah.
Just run to the biggest hole in the dike and stick your finger in and ignore the little holes until they become big holes, and then go put your finger in that hole. Or it's like when you go whale watching. Oh, so everybody's on the starboard side of the boat. Hey, the whale's on the other side. Everybody runs to the other side of the boat, goes, whoa! That's how immigration runs their system. It's.
Well, I don't want to be the cynic out there that says that, an administration is trying to naturalize people more quickly for political gains, but they,
Done that before.
We're not going to say that. But what we are going to say is that that they should be able. This is not something that they haven't been able to do in the past to manage all of this stuff. Yeah, they want more fees and everything like that, but they ultimately, at the end of the day, a lot of this is inflicted on themselves just with the way they internally process all this stuff. But they make things way harder for themselves than they need to. So we're going to give them some help. We're going to encourage them to figure out ways to streamline and to get times back to normal by.
But Greg, we do expect a motion to dismiss that says we have no legal obligation to do these cases the rest of the time you're alive. So we do expect that motion. And maybe we'll stick that in the complaint. So we'll be onboarding on that case for I-129Fs, which are fiancés, and I-130. These are people that are abroad, not an I-130 kids.
Right.
And it's for spouses, but it's also if you're parents, a parent I-130 or a child under 21. So it's any of those categories, not just spouses. So,
well, the parents are particularly upsetting, I think, because, in a lot of cases, they're elderly. They need to be with their families. They're really kind of isolated without help, and they need to be reunited with their kids. So
now, Jesse, when I went to your session at the conference, you did not have a prop, but I did. So we just urged our fellow immigration lawyers, be a little bit more of a shark. Get out there and bite these guys occasionally.
Yeah.
All right, let's just get out there and do that.
We need to do that.
All right, a couple questions. Oh yes, we explained the joint status report. Information we talked about that's being submitted today because I'm making sure it's getting submitted today. Greg, have you heard back from Jonna yet and your clerk?
You just asked.
We have to redo a declaration is what it is. So hopefully we'll get it done shortly.
I will let you know in a minute.
No, there is nothing. USCIS had an open forum, and it was the most self-congratulatory, pat-backing forum of the conference. Oh, look at us and how great we are. So no, there's no 601 other than they're getting worse, and they're now at 44 months processing times. By the way, we did point out in the filing we'll be putting today that despite the declaration to the court by the government 2 months ago that they created the HART Service Center, processing times have actually gotten worse. So we did note that. T Lions, we already told you that's been extended to June 30th despite our opposition. Go now. I mean, Jesse, this becomes a little crazy now. We are almost 9 months now.
Yeah.
Wow.
I think again, no one should listen to what I say, but I do think it's coming. There was a decision today in a case that right around the same time, IT Serve case came out today.
Did it really?
Yeah.
What was the decision on that case?
When was it or what?
What was it? What was it? How did it?
They affirmed the district court's decision, and honestly, I have not even looked at it. But our colleagues were, and I didn't work on that case, but I know it was briefed and argued around the same time. So I do think, again, it's coming. I know it is, and it's almost like the Supreme Court, where they're waiting to issue like these blockbuster decisions on affirmative action, and they're starting to build up and issue decisions that have bigger and bigger ramifications. I think this one is coming. They actually, speaking of the DC Circuit, they actually issued a decision the other day on consular non-reviewability that is absolutely a travesty. Calindrus. Oh, don't even get me started. I mean, they basically said there's no liberty interest in allowing your spouse to live with you in the United States. And so they basically undercut the plurality. Like, this is getting nerdy, but in DIN, you could never have any review based on like the majority panel's decision.
So they took DIN and they ran away from it. And
absolutely. And they've been doing that. They the DC Circuit is the most strict on like their consular non-reviewability. Now, of final decisions. Now, you still have the government going out there and saying that it applies to non-final decisions, which drives me insane. But yeah, so the DC Circuit is really issuing. They're issuing big decisions regarding immigration policy. I expect Gomez, good luck, to come out and it be issued. And
Okay, so Katsas wrote the opinion in the IT Serve Alliance case.
Yeah.
But it's not related to our case. It was an issue of the filing requirements to file amendments of H-1Bs, which I think has kind of been resolved anyway by policy. So, but that was our friend Josh Press was government counsel on that case. Yes.
Yeah.
All right.
DB 2020.
So look quickly. Look soon. Hopefully. This is, I think they argued that about a month before ours.
You may be right.
About a month before ours. I think so. All right. So next question. We hope we're doing great. We came back from the AILA conference ready to fight even harder.
I gotta be honest with you. I'm not doing great today.
Oh, just hey. Yeah.
I need a shark. Can you send me a shark?
You'd have to call Law Clerk Legal. They'll send you.
Oh, damn it! I missed that whole exhibition.
You didn't take your boys to the conference and let them go. We went to the conference for years when we had little kids, and we would literally give them Halloween bags, and they would walk through the vendors and just 80,000 pens and all kinds of tchotchkes like this. It was just great.
No.
All right, Kiara, U.S. changed our automatic phone line. Now we cannot talk by secret info pass. They asked why. Do I know the secret to 1-800-USELESS? I do not. But I do know that if you go and use the chat feature and say, I need to talk to an officer because I have an emergency, generally you'll get to talk to an officer. Use the chat feature. It does work. Rachel, if we choose an individual mandamus, yes, if you're going to file individually, you need to tell us we need to withdraw from the case. You can only have one case pending at a time.
I think just be careful if it's a 601A issue. They've really marked all of them, and they're filing motions to dismiss in all the individual cases.
Everybody's getting a motion to dismiss. So
yeah. So
General Grievous is back.
I like that logo.
I have an integration question. Where can I email? You can email gsiskin.
Oh, come on.
Isn't that where you can do? You can J Siskin. I think that's what you can do. You can also interview me. Greg, Jesse does not want your individual case questions. I can tell you that.
That is not true. I mean, if it's litigation related, of course
litigation,
I do.
But I don't think there's litigation. So
yeah,
you could do that. Let's see. The new 80
You don't have that post AILA massive backlog of emails like I do that it's going to take me 2 weeks to get through.
Dude, I'm already caught up. Don't you have a cell phone?
Oh my god!
Wait, all right. There's a
half of the messages are from you.
Well,
right.
You're answering me.
I have 17 emails from Chuck today.
Chuck said I sent you an email earlier today.
And I had a 3-hour.
Is it this one? Is it this one? Is it this one?
I had a 3-hour adjustment interview this morning. I had plenty of time to send emails. The compelling circumstance EAD does not apply to anyone who's undocumented. It only applies to certain non-immigrants. 6-1, go back to the first 7 minutes, Angela. Your case was moved again? Greg, did we have any other movement?
Not according to our...
Well, that's news to us. Okay. Final result. I love when people want to know what's the deadline to get an answer. And Gustavo, we have actually said many months ago, we think we have this resolved by the end of the year. I mean, I still think that, but we just don't know what the judge is doing. I mean, with the last judge, we were pretty, we were moving along. We had everything set, and now we're just kind of in a limbo with the new judge. So, I just say hang in there, and we'll see where we go. Just know we're fighting. We're doing everything we can to move it forward.
Right. I don't think we're going to have a final result. I think they'll, if we survive a motion to dismiss, maybe there's a potential to get some type of benchmark settlement or order. But yeah, they're listen, they're not willing to help. So
right now they're like, don't touch me.
Right. Well, and they've won. They've convinced judges that they can take a look. I
read that decision out of Virginia.
Yeah,
it's junk. It's a junk decision.
They appealed it. They appealed it to the Fourth Circuit. I mean,
they should have, because it's a junk decision.
Yeah, it's
and
that's where maybe this needs to go. And I'm not so sure in the DC Circuit, but I think the other circuit courts really, they're a little bit removed and maybe a little bit more attached to reality than some of these district court judges that seem like they just don't care. About how they have the authority to actually look and say, this isn't reasonable. 6 years isn't reasonable for work authorization. Like, okay, right? That makes sense.
You have to renew every single year anyway. So how is that reasonable? So,
yeah, like how, I don't know. Like, I feel like I wish I could make the better case. to they don't hold argument on these cases. That's the problem.
Part of the problem, right? If we could just get that's why I want a status conference and oral argument. I want argument. It's what I love to do.
You're the shark.
Be the shark, baby. Hey, it's great to be with you guys. Just buck up, Buckaroo. It's gonna be okay.
I got my kid on the bump tonight pitching, so he's gonna.
Oh, that's awesome, baby.
He's gonna strike out 18, so we'll be fine.
I want to see him strike out Teddy Banash. That's what I want to see.
Kid's a lefty with a slider. So
Get a slider? How about his curveball? Can he throw a curve yet?
No, he's only 12.
Surely his hands aren't big enough to throw a knuckleball, so you can't teach him that yet. So
no, not yet.
All right, you guys have a good week. We'll see you guys next Wednesday. I'll be live tomorrow at noon. See you guys next Tuesday.